Question 1. An investment advisor representative, IAR, in State A begins working for a new investment advisor firm. The IAR has several existing clients who reside in State B, where the IAR was previously registered. Under the Uniform Securities Act, USA, what is the most appropriate action for the IAR regarding clients in State B? A. The IAR must re-register immediately in State B under the new firm sponsorship, and clients cannot be serviced until registration is effective. B. The IAR may service existing clients in State B for 30 days while the new registration is pending, provided both firms are registered in State B. C. The IAR is automatically registered in State B under the new firm sponsorship since they were previously registered there. D. Clients in State B must find a new IAR who is registered in their state, as the IAR cannot transfer their registration. Answer. A. The IAR must re-register immediately in State B under the new firm sponsorship, and clients cannot be serviced until registration is effective. Under the Uniform Securities Act, USA, when an investment advisor representative, IR, changes firms, their registration is terminated upon withdrawal from the old firm and they must re-register under the new firm sponsorship. There is no temporary exemption for IARs to service clients in another state while a new registration is pending, unlike some provisions for agents. Therefore, the IAR cannot conduct advisory business in State B until their new registration with the new firm is fully effective in that state. It is crucial to understand the distinct registration requirements and transferability rules for agents versus IARs. Question 2. A broker-dealer's agent recommends a speculative growth stock to an elderly client whose stated investment objective is capital preservation and income. The agent informs the client that the stock is a guaranteed winner based on their proprietary analysis. Which of the following statements best describes the agent's actions? A. The agent is merely engaging in aggressive sales tactics, which are permissible if disclosed. B. The agent has violated suitability rules and made an unethical representation regarding a guarantee. C. The agent's actions are acceptable if the client signs a waiver acknowledging the risk. D. The agent has only violated suitability rules, but not made an unethical representation. Answer, B. The agent has violated suitability rules and made an unethical representation regarding a guarantee. The agent's actions constitute two distinct violations under the Uniform Securities Act, USA. Recommending a speculative stock to a client focused on capital preservation and income is a clear violation of suitability rules, as the recommendation does not align with the client's investment objectives. Furthermore, stating that a stock is a guaranteed winner is an unethical business practice, as no investment can be guaranteed. Advisors and agents must always provide recommendations consistent with client profiles and avoid making misleading or unfounded assurances about investment performance. Question 3. A charitable organization, exempt from federal taxation under IRS Section 501(c)(3), wishes to issue bonds to finance the construction of a new facility. Under the Uniform Securities Act, USA, the offer and sale of these bonds would most likely be considered a non-exempt security requiring full state registration, b. an exempt security, thus not requiring state registration, c. an exempt transaction, rather than an exempt security, d. a federal covered security, exempt from state registration. Answer, B. An exempt security, thus not requiring state registration. Under the Uniform Securities Act, USA, securities issued by persons organized and operated exclusively for religious, educational, benevolent, fraternal, charitable, or reformatory purposes, and not for pecuniary profit, are considered exempt securities. This exemption applies provided no part of the net earnings benefits any private shareholder or individual. Therefore, bonds issued by a 501(c)(3) charitable organization to finance its operations would typically be exempt from state registration requirements. Understanding the specific categories of exempt securities is critical for compliance. Question 4. An agent of a broker-dealer is granted discretionary authority over a client's account verbally by the client. The agent proceeds to execute several trades. Which of the following is true regarding this situation under the Uniform Securities Act, USA? A. Verbal discretionary authority is permissible for up to 10 business days before written authorization is required. B. The agent has engaged in an unethical business practice by exercising discretion without written authorization. C. Discretionary authority can be granted verbally as long as the trades are suitable for the client. D. The agent can exercise discretion for trades involving only exempt securities without written authorization. Answer, B. The agent has engaged in an unethical business practice by exercising discretion without written authorization. Under the Uniform Securities Act, USA, exercising discretionary authority in a client's account without obtaining proper written authorization is considered an unethical and prohibited business practice. Verbal authorization is insufficient, and written consent must be obtained from the client before any discretionary trades are executed. This rule protects clients by ensuring they explicitly grant permission for someone else to make trading decisions on their behalf. The key takeaway is that written authorization is a fundamental requirement for discretionary accounts, regardless of suitability or the type of security involved. Question 5. An investment advisor, IA, has its principal office in State A and exclusively manages the portfolios of mutual funds. The IA has no direct clients who are natural persons. Under the Uniform Securities Act, USA, this IA would most likely be required to register with A. The Administrator of State A. B. The Securities and Exchange Commission, SAC. C. Both the Administrator of State A and the SEC. D. Neither the Administrator nor the SEC, due to the nature of its clients. Answer, B. The Securities and Exchange Commission, SAC. Investment advisors that exclusively advise federally covered investment companies, such as mutual funds, are considered federal covered investment advisors. Federal covered investment advisors are required to register solely with the Securities and Exchange Commission, SAC, and are exempt from state registration requirements. While states may still require notice filing, paying a fee and submitting copies of SEC filings, they do not directly register these firms. This avoids dual registration and streamlines regulation for advisors to federally recognized entities. Question 6. Which of the following would not be considered an offer or offer to sell a security under the Uniform Securities Act, USA? A. A bonus given with the purchase of a security. B. A gift of assessable stock. C. An advertisement for a security in a national financial newspaper. D. A bona fide pledge or loan of a security. Answer, D. A bona fide pledge or loan of a security. Under the Uniform Securities Act, USA, a bona fide pledge or loan of a security is specifically excluded from the definitions of offer or offer to sell. An offer generally includes any attempt to dispose of, or solicitation of an offer to buy, a security or interest in a security for value. However, a pledge or loan does not involve the disposal of the security for value in the same manner as a sale or gift of assessable stock. Understanding these specific exclusions is important for correctly applying the Act's provisions. Question 7. A state administrator has reason to believe that a registered agent has engaged in multiple violations of the Uniform Securities Act, USA. The administrator issues a cease and desist order without a prior hearing. Which of the following statements is true regarding this action? A. The administrator lacks the authority to issue a cease and desist order without a prior hearing. B. The administrator may issue a cease and desist order without a prior hearing, but the affected party must be granted an opportunity for a hearing upon request. C. Cease and desist orders always require a full hearing and judicial review before issuance. D. The administrator can issue a cease and desist order with immediate effect, and no hearing is required. Answer, B. The administrator may issue a cease and desist order without a prior hearing, but the affected party must be granted an opportunity for a hearing upon request. Under the Uniform Securities Act, USA, a state administrator has the authority to issue a cease and desist order without a prior hearing if they deem it necessary to protect the public interest. However, a fundamental principle of due process requires that the affected person must be promptly notified and granted an opportunity for a hearing upon written request. This balances the administrator's need for immediate action with the rights of the individual or firm. Understanding the administrator's investigatory and enforcement powers, along with the associated due process requirements, is crucial. Question 8. An agent with a broker-dealer wants to share in the profits and losses of a client's account. Under the Uniform Securities Act, USA, which of the following conditions must be met for this to be permissible? A. The agent must obtain written authorization from the client only. B. The agent must obtain written authorization from the client and the broker-dealer. C. Sharing in profits and losses is strictly prohibited for agents under any circumstances. D. The agent can share in profits and losses if the client is a family member. Answer, B. The agent must obtain written authorization from the client and the broker-dealer. Under the Uniform Securities Act, USA, an agent is generally prohibited from sharing in the profits and losses of a client's account. However, this rule has a narrow exception. It is permissible only if the agent obtains prior written authorization from both the client and the broker-dealer. This stringent requirement ensures transparency and protects against potential conflicts of interest or undue influence. The key takeaway is that dual written consent is absolutely necessary for agents to participate in client account performance. Question 9. Which of the following securities is least likely to be considered an exempt security under the Uniform Securities Act, USA, and therefore most likely requires registration? A. A bond issued by the Canadian provincial government. B. A share of stock in a small, privately held manufacturing company. C. A security issued by a federal credit union. D. A bond issued by a municipality in another state. Answer, B. A share of stock in a small, privately held manufacturing company. Under the Uniform Securities Act, USA, several types of securities are exempt from registration, including securities issued by the U.S. government, municipalities, banks, federal credit unions, and even certain foreign governments, like Canada and its political subdivisions, provided they are recognized by the U.S. government. A share of stock in a small, privately held manufacturing company, however, does not typically fall under any of these general exempt categories and would most likely require registration with the state administrator unless a transaction exemption applies. It is vital to differentiate between exempt securities and exempt transactions. Question 10. An investment advisor representative, IR, sends out marketing materials claiming they are a certified financial planner, CFP, when they have not completed the required certification. Under the Uniform Securities Act, USA, this advertisement is considered A. Permissible, as long as they are working towards the certification. B. Permissible, if accompanied by a disclaimer. C. An unethical and fraudulent business practice. D. Permissible for IARs, but not for agents of broker-dealers. Answer, C. An unethical and fraudulent business practice. Under the Uniform Securities Act, USA, misrepresenting professional qualifications or designations is considered an unethical and fraudulent business practice for investment advisors and IARs. Clients rely on accurate information about an advisor's credentials, and falsely claiming a certification like Certified Financial Planner, CFP, is misleading. Such statements violate the principles of fair and balanced communication and client trust. IARs must always accurately represent their qualifications. Question 11. An investment advisor, IA, has its principal office in State X and manages $90 million in assets for clients solely within State X. They have 15 retail clients. Under the Uniform Securities Act, USA, this person is most likely required to register with A. Only the administrator of State X. B. The SEC, Securities and Exchange Commission, and notice file in State X. C. Both the administrator of State X and the SEC. D. Neither the administrator nor the SEC, due to the number of clients. Answer. A. Only the administrator of State X. Under the Dodd-Frank Act amendments to the Investment Advisors Act of 1940, investment advisors managing less than $100 million in assets are generally required to register with the state administrator, S, where they have a place of business or exceed the de minimis client threshold. Since this IA manages $90 million AUM, below the $100 million federal threshold D, and has its principal office and 15 retail clients in State X, it is a state-registered investment advisor. It would not register with the SEC unless its AUM reached $100 million or more, or for certain other conditions, such as advising a registered investment company. Question 12. Which of the following situations would typically trigger the requirement for a broker-dealer to maintain a surety bond under the Uniform Securities Act, USA? A. The broker-dealer has a minimum net capital requirement of $25,000. B. The broker-dealer maintains custody of client funds or securities. C. The broker-dealer exclusively deals in exempt securities. D. The broker-dealer registers with the administrator via coordination. Answer, B. The broker-dealer maintains custody of client funds or securities. Under the Uniform Securities Act, USA, the administrator may require a registered broker-dealer, agent, or investment advisor to post a surety bond. This requirement is typically triggered if the firm or individual has custody of client funds or securities, or if they have discretionary authority over client accounts. The bond serves as a financial guarantee to protect clients against losses resulting from the registrant's misconduct or insolvency. While minimum net capital is a separate requirement, it doesn't always obviate the need for a bond when custody or discretion is involved. This ensures a layer of client protection. Question 13. A prospectus for a new issue of common stock is being distributed. The prospectus contains a statement that the administrator has approved these securities. Under the Uniform Securities Act, USA, this statement is A. Permissible, as long as it is factually true that the administrator registered the securities. B. Permissible, as it indicates the securities have met state registration requirements. C. Misleading and unlawful, as registration does not imply approval of merit. D. Required, to inform investors that the securities have been vetted by the state. Answer, C. Misleading and unlawful, as registration does not imply approval of merit. Under the Uniform Securities Act, USA, it is unlawful to state or imply that the administrator, or any regulatory body, has approved or passed upon the merits of any security or transaction. Registration means only that the issuer has met the required filing and disclosure standards. It does not constitute an endorsement or guarantee of the investment's safety or profitability. Such statements are considered misleading and fraudulent because they falsely suggest governmental endorsement. The key takeaway is that regulators register, but never approve, securities. Question 14. An isolated non-issuer transaction, under the Uniform Securities Act, USA, would most likely apply to A. A block trade of securities executed by a broker-dealer for a large institutional client. B. An investor selling a small block of stock directly to another individual without involving a broker-dealer. C. An issuer offering new shares to a limited number of sophisticated investors. D. A sale of securities by an underwriter in a public offering. Answer: B. An investor selling a small block of stock directly to another individual without involving a broker-dealer. An isolated non-issuer transaction is an exempt transaction under the Uniform Securities Act, USA, meaning it does not require registration. It refers to a transaction between individuals, typically infrequent, and not for the benefit of the issuer. This exemption typically applies to a single investor selling shares to another individual, not through a broker-dealer, and where the issuer is not involved in the transaction. This exemption is designed to avoid burdening individuals with registration requirements for infrequent, personal sales. The key is understanding that non-issuer means the issuer is not benefiting from the sale, and isolated implies infrequent occurrence. Question 15. Which of the following actions by an investment advisor representative, IR, would not be considered a prohibited practice under the Uniform Securities Act, USA? A. Sending out marketing materials that project specific future performance based on hypothetical scenarios. B. Failing to disclose to a client that the IAR receives a higher commission for recommending certain proprietary products. C. Maintaining custody of client funds with proper notification to the administrator and separate accounts. D. Exercising discretionary authority in a client's account without prior written consent. Answer: C. Maintaining custody of client funds with proper notification to the administrator and separate accounts. Maintaining custody of client funds is a high-risk activity for investment advisors and IARs, but it is not inherently prohibited if proper procedures are followed. These procedures include notifying the administrator, maintaining funds and securities in separate accounts for each client, and periodic audits. The other options listed, projecting specific future performance, failing to disclose conflicts of interest, and exercising discretion without written consent, are all clear examples of prohibited or unethical practices. The key distinction is between a prohibited action and an action that is permissible only under strict regulatory compliance. Question 16. An individual provides investment advice to clients for a fee and also executes trades for those clients. This individual primarily focuses on fixed income securities and has 8 retail clients in State Z, where they have no office. Under the Uniform Securities Act, USA, this individual would most likely be required to register as A. An agent only. B. An investment advisor only. C. Both an agent and an investment advisor. D. Neither, due to the de minimis exemption. Answer: C. Both an agent and an investment advisor. This individual meets the definition of both an agent and an investment advisor. By executing trades, they are acting as an agent for a broker-dealer, or as a broker-dealer themselves if they aren't associated with one, and by providing advice for a fee, they meet the definition of an investment advisor. Since they have 8 retail clients in State Z, more than 5, the de minimis exemption for State IA registration does not apply. Therefore, they would need to be registered as both an agent and an investment advisor in State Z, provided they meet the definition of both. Question 17. Which of the following is an example of an exempt transaction under the Uniform Securities Act, USA, but not an exempt security? A. U.S. government bond sold to a retail investor. B. A non-issuer transaction in an outstanding publicly traded stock. C. A municipal bond issued by a city in the state where it's being sold. D. A security issued by a federal savings and loan association. Answer: B. A non-issuer transaction in an outstanding publicly traded stock. A non-issuer transaction in an outstanding publicly traded stock, e.g., a secondary market trade by an individual investor, is generally an exempt transaction under the USA, often falling under the unsolicited order exemption or secondary market trading through a broker-dealer. However, the publicly traded stock itself, unless it falls into a specific category like those issued by banks or governments, is not an exempt security. U.S. government bonds, municipal bonds, and Federal Savings and Loan Association securities are all examples of exempt securities. This distinction highlights that an exempt transaction relates to the circumstances of the sale, while an exempt security refers to the nature of the security itself. Question 18. A broker-dealer allows a client to place an order for a security without first obtaining all required new account documentation. The client explicitly states they want to buy 100 shares of XYZ stock. The order is executed. Which of the following is true? A. The broker-dealer violated regulations by executing an order without complete new account documentation. B. The broker-dealer is permitted to execute unsolicited orders even if the account documentation is incomplete. C. This action is acceptable if the order is suitable for the client. D. The broker-dealer only violated suitability rules, but not documentation rules. Answer. A. The broker-dealer violated regulations by executing an order without complete new account documentation. Under the Uniform Securities Act, USA, and general industry regulations, a broker-dealer must obtain all required new account documentation and establish the customer's identity before executing any transactions for that account, even if the order is unsolicited. While unsolicited orders may be exempt from suitability requirements in some contexts, the fundamental obligation to gather account information for identification and other regulatory purposes remains. Failing to complete new account documentation before trading is a serious procedural violation. The takeaway is that proper client identification and account opening procedures are paramount before any transactions can occur. Question 19. An investment advisor, IA, currently registered in State A and not federally covered, plans to open a new office and solicit clients in State B. Under the Uniform Securities Act, USA, what is the most accurate statement regarding its registration in State B? A. It must register with the administrator of State B before opening the office or soliciting clients. B. It must only notice file with the administrator of State B, as it's already registered in State A. C. It is exempt from registration in State B unless it has more than 5 clients in State B. D. It can operate in State B under its State A registration for up to 60 days before needing to register in State B. Answer. A. It must register with the administrator of State B before opening the office or soliciting clients. Under the Uniform Securities Act, USA, a state-registered investment advisor must register in any state where it has a place of business, regardless of the number of clients, or in any state where it has more than 5 clients, if it does not have a place of business there. Since the IA plans to open a new office in State B and solicit clients, it establishes a place of business and must therefore register with the administrator of State B. The de minimis exemption, 5 clients or less, applies only if the IA does not have a place of business in the state. Question 20. An agent registered in State A wishes to solicit new clients in State B. The agent travels to State B for a weekend and meets with potential clients at a conference. The agent does not have an office in State B. Under the Uniform Securities Act, USA, what is required? A. The agent must register in State B before soliciting any clients. B. The agent can solicit up to 5 clients in State B before registration is required. C. The agent can solicit clients in State B if their broker-dealer is registered in State B. D. The agent is exempt from registration in State B as long as they do not establish a permanent office there. Answer. A. The agent must register in State B before soliciting any clients. Under the Uniform Securities Act, USA, an agent must be registered in any state where they solicit or transact business, regardless of whether they have a physical office there. There is no de minimis exemption for agents to solicit new clients in a state where they are not registered. The act of soliciting clients constitutes transacting business and requires registration. The takeaway is that agents' registration requirements are broad, focusing on the location of the client and the activity of the agent, not just the physical location of their office. Question 21. An investment advisor, IA, has decided to withdraw its registration with the state administrator. When does the withdrawal become effective under the Uniform Securities Act, USA? A. Immediately upon filing the Form ADVW. B. 30 days after the filing of the Form ADVW, or earlier if determined by the administrator. C. 60 days after the filing of the Form ADVW, or earlier if determined by the administrator. D. Only after the administrator conducts a full audit of the IA's records. Answer: C. 60 days after the filing of the Form ADVW, or earlier if determined by the administrator. Under the Uniform Securities Act, USA, a withdrawal of registration for an investment advisor generally becomes effective 60 days after the administrator receives the application for withdrawal, Form ADVW, or within a shorter period as the administrator may determine. However, the administrator retains jurisdiction over the applicant for 1 year after the effective date of withdrawal for the purpose of commencing a proceeding to deny, suspend, or revoke registration. This delay allows the administrator time to review the firm's books and records before the withdrawal is finalized. It is important to remember this specific timeframe for withdrawal effectiveness. Question 22. Which of the following is not a security under the Uniform Securities Act, USA? A. An oil and gas limited partnership interest. B. A variable annuity contract. C. A fixed annuity contract. D. A collateral trust certificate. Answer: C. A fixed annuity contract. Under the Uniform Securities Act, USA, the definition of a security is broad but generally excludes certain products. While variable annuities are considered securities because their value fluctuates based on the performance of an underlying investment portfolio, fixed annuity contracts typically are not. Fixed annuities offer a guaranteed rate of return or payout, and the insurer bears the investment risk, making them more akin to an insurance product than an investment security. Limited partnership interests and collateral trust certificates are generally considered securities. Understanding the specific exclusions from the definition of a security is crucial for determining regulatory oversight. Question 23. An investment advisor representative, IAR, is selling her personal home and provides private financing to the buyer. The buyer is also a client of the IAR. This transaction is considered A. Permissible, as long as the IAR discloses the personal relationship. B. A form of selling away, requiring notification to the broker-dealer. C. A conflict of interest that must be disclosed to the client, but not necessarily prohibited. D. A transaction where the IAR and client are on opposite sides, which is always prohibited. Answer: C. A conflict of interest that must be disclosed to the client, but not necessarily prohibited. While the IAR is engaging in a personal transaction, selling a home and providing financing to a client creates a potential conflict of interest. The IAR has a fiduciary duty to the client, and this personal business relationship could compromise the objectivity of investment advice. The transaction itself is not an investment security transaction, so it wouldn't be selling away in the securities context. However, the conflict must be fully disclosed to the client, and if the administrator deems it unduly influences the advisory relationship, it could be prohibited. The key takeaway is that IARs must be acutely aware of and disclose all potential conflicts of interest, even those arising outside of direct securities transactions. Question 24. An administrator may deny, suspend, or revoke the registration of a person if it finds that the order is in the public interest and that the person a. has filed a complete, but late, application for registration. b. has been convicted of any misdemeanor offense within the last 5 years. c. is insolvent, but can still meet all financial obligations. d. has failed to pay the proper filing fee after multiple notices. Answer: D. has failed to pay the proper filing fee after multiple notices. Under the Uniform Securities Act, USA, the administrator must find 2 things to deny, suspend, or revoke a registration. It must be in the public interest, and a specific statutory disqualifying event must have occurred. Failing to pay filing fees, especially after notice, is a legitimate grounds for the administrator to take action against a registration. Conviction of any misdemeanor is too broad. Typically, it refers to securities-related misdemeanors or felonies within the last 10 years. Insolvent but meeting obligations is contradictory, and a complete but late application might incur fees but not necessarily a full denial. This highlights the specific statutory reasons for administrator action. Question 25. An investment advisor representative, IR, maintains a personal brokerage account where they execute trades identical to those recommended to clients. The IAR often trades for their own account immediately after placing client orders but before the client orders are fully executed. This practice is known as A. Market manipulation. B. Front running. C. Soft dollar arrangements. D. Churning. Answer: B. Front running. This practice is known as front running, which is a prohibited and unethical business practice. Front running occurs when an IAR or agent executes trades for their own account with prior knowledge of pending client orders, anticipating the market impact of those large client orders. This allows the professional to profit at the expense of their clients or the integrity of the market. Churning involves excessive trading, soft dollars are for research, and market manipulation is a broader term for artificial influence on prices. Recognizing and preventing front-running is critical to maintaining fiduciary duty and market fairness. Question 26. Which of the following is considered an issuer transaction under the Uniform Securities Act, USA? A. A secondary market trade of Google stock between 2 individuals. B. A private placement where a company sells new stock directly to a venture capital firm. C. An estate executor selling a deceased person's entire stock portfolio. D. A broker-dealer selling shares from its inventory to a client. Answer: B. A private placement where a company sells new stock directly to a venture capital firm. An issuer transaction is one in which the proceeds of the sale go to the issuer. When a company sells its newly issued stock, whether in a public offering or a private placement, the company itself, the issuer, receives the funds. This is distinct from secondary market trades, where existing shares change hands between investors and the issuer receives no proceeds, or sales from a broker-dealer's inventory, which are dealer transactions. Understanding whose benefit the transaction serves is key to defining an issuer transaction. Question 27. A state administrator has the power to A. Grant permanent exemptions from registration for certain securities or transactions. B. Revoke a broker-dealer's registration retroactively for past violations. C. Subpoena witnesses and compel testimony related to an investigation. D. Imprison individuals for violations of the Uniform Securities Act, USA. Answer: C. Subpoena witnesses and compel testimony related to an investigation. Under the Uniform Securities Act, USA, a state administrator is granted significant investigative and enforcement powers. These powers include the ability to subpoena witnesses, administer oaths, and compel testimony or the production of books and records relevant to an investigation. However, the administrator cannot directly imprison individuals. Criminal penalties are imposed by courts. While the administrator can deny, suspend, or revoke registration, such actions are typically not retroactive. Understanding the specific limits and scope of the administrator's authority is essential for exam candidates. Question 28. An agent recommends a security to a client, but deliberately omits disclosing a recent lawsuit filed against the issuing company, which could significantly impact its value. This action is A. Permissible if the agent believes the lawsuit will be dismissed. B. A violation of the anti-fraud provisions of the USA because it omits material facts. C. Only a violation if the client specifically asks about lawsuits. D. Permissible if the prospectus mentions the possibility of lawsuits in general terms. Answer, B. A violation of the anti-fraud provisions of the USA because it omits material facts. Deliberately omitting a material fact, such as a significant lawsuit against an issuing company, when recommending a security is a clear violation of the anti-fraud provisions of the Uniform Securities Act, USA. Agents have an obligation to provide all material information necessary for a client to make an informed investment decision. Failing to disclose such critical information is misleading and can be considered a fraudulent act, regardless of the agent's personal beliefs about the lawsuit's outcome or the general disclosures in a prospectus. Question 29. Under the Uniform Securities Act, USA, which of the following records must an investment advisor typically keep for a minimum of 5 years? A. Original order tickets. B. Advertising and sales literature. C. Client correspondence. D. All of the above. Answer, D. All of the above. Investment advisors, under the Uniform Securities Act, USA, are required to maintain a wide range of books and records for specific periods to ensure regulatory oversight and client protection. This includes original order tickets, advertising and sales literature, and client correspondence, among many other documents. Generally, these records must be preserved for 5 years, with the first 2 years in an easily accessible location. Comprehensive record-keeping ensures accountability and aids in regulatory examinations. Thus, all the listed records fall under the typical 5-year retention requirement. Question 30. An investment advisor representative, IAR, is moving from one registered investment advisor firm to another. Both firms are state-registered in the same state. Which of the following statements is true regarding the IAR's registration transfer under the Uniform Securities Act, USA? A. The IAR's registration automatically transfers to the new firm once the new firm is notified. B. Only the new firm must notify the administrator of the employment of the IAR. C. Only the IAR must notify the administrator of the change in employment. D. Both the old firm and the new firm must notify the administrator of the IAR's change in employment. Answer, D. Both the old firm and the new firm must notify the administrator of the IAR's change in employment. Under the Uniform Securities Act, USA, when an investment advisor representative, IR, terminates employment with one state-registered investment advisor and begins employment with another state-registered investment advisor, both the departing firm and the new firm have an obligation to promptly notify the administrator. This dual notification ensures that the administrator is fully aware of the IAR's employment status and maintains accurate registration records. Understanding this specific notification responsibility for IARs is critical, as it differs from the rule for agents of broker-dealers where only the firm files. The key takeaway is to remember that both firms rule for IAR transfers. Question 31. A broker-dealer sells securities to a client from its own inventory, principal transaction, without disclosing its capacity in the transaction. This action is considered A. Permissible, as long as the price is fair and reasonable. B. An unethical business practice, as the capacity must be disclosed. C. Only problematic if the broker-dealer makes an excessive profit. D. Permissible, as long as the client is sophisticated. Answer, B. An unethical business practice, as the capacity must be disclosed. Under the Uniform Securities Act, USA, a broker-dealer acting in a principal capacity, selling securities from its own inventory, to a client must disclose its capacity to the client, either verbally before the transaction or in writing at or before the completion of the transaction. Failing to disclose that the firm is acting as a principal creates a conflict of interest and is considered an unethical business practice. This ensures transparency and allows the client to understand that the firm is on the opposite side of their trade. The key takeaway is that capacity disclosure is mandatory for principal transactions. Question 32. Which of the following would be subject to regulation as an investment advisor under the Uniform Securities Act, USA? A. A bank or bank holding company. B. A person who advises clients solely on real estate investments for a fee. C. A pension consultant who advises employee benefit plans on selecting investment managers for a fee. D. A publisher of an investment newsletter distributed to 10,000 subscribers, making general recommendations. Answer, C. A pension consultant who advises employee benefit plans on selecting investment managers for a fee. A pension consultant who advises employee benefit plans on selecting investment managers for a fee clearly meets the three-pronged definition of an investment advisor, providing advice on securities, indirectly, by advising on managers who invest in securities, doing so as a business, and receiving compensation. Banks are typically excluded from the definition of an IA. Advice solely on real estate is not advice on securities. A publisher of a general circulation newsletter making impersonal advice is generally excluded. This question tests the nuanced application of the investment advisor definition and its common exclusions. Question 33. An administrator may require an investment advisor to have a minimum net worth if the advisor A. Has clients who are all institutional investors. B. Only manages federal covered securities. C. Has custody of client funds or securities. D. Only provides advice on municipal bonds. Answer, C. Has custody of client funds or securities. Under the Uniform Securities Act, USA, the administrator may impose minimum net worth requirements on investment advisors who have custody of client funds or securities, or who have discretionary authority over client accounts. These financial requirements are designed to provide a layer of financial protection for clients in case of firm insolvency or malfeasance. Investment advisors that do not maintain custody or exercise discretion are generally not subject to these minimum net worth requirements. The key takeaway is that stricter financial requirements are tied to higher risk activities involving client assets. Question 34. A client tells an agent that they wish to purchase shares of Company X, but then adds, "Do whatever you think is best regarding the execution price and timing." This grants the agent A. Full discretion over the account. B. Time and price discretion. C. No discretion, as it must be in writing. D. Limited discretion over the account. Answer, B. Time and price discretion. The client's instruction grants the agent time and price discretion or not held order discretion. This means the agent has authority to decide the time and price at which to execute the specified order for Company X, without specific written authorization. However, this limited discretion does not extend to choosing the asset, security, amount, or action, buy, sell, which would require full discretionary authority in writing. This type of discretion is temporary and related to a specific order, not the entire account. Understanding the distinction between full discretionary authority and time/price discretion is crucial. Question 35. Which of the following is an accurate statement regarding the statute of limitations for civil liabilities under the Uniform Securities Act, USA? A. Actions must be brought within 1 year of discovery or 3 years of the sale, whichever is earlier. B. Actions must be brought within 2 years of discovery or 3 years of the sale, whichever is earlier. C. Actions must be brought within 3 years of discovery or 5 years of the sale, whichever is earlier. D. Actions must be brought within 2 years of discovery or 5 years of the sale, whichever is earlier. Answer: B. Actions must be brought within 2 years of discovery or 3 years of the sale, whichever is earlier. Under the Uniform Securities Act, USA, the statute of limitations for civil liabilities states that an action must be brought at the earlier of 2 years after discovery of the facts constituting the violation, or 3 years after the contract of sale. This provision ensures that claims are made in a timely manner while also providing a reasonable period for investors to discover potential violations.